Hi everyone! Welcome to my channel. Always remember, ignorance of the law excuses no one. This is Legally Engineer. Good day to everyone. We are here again to discuss to you joint and solidary obligations. Again, I am Attorney Pendricky Maralit.
And I'm Attorney April Uy.
And we hope you'll learn from this discussion. So, Attorney Uy, ano ba tong joint and solidary obligations? Saan ba itong matatagpuan sa Civil Code?
So it is found in Article 1207 of the new Civil Code.
So we invite everyone to refer to Article 1207 of the new Civil Code. So
Yes.
i-define natin to para makita natin yung distinction ng joint and solidary. Ano ba tong joint obligation, Attorney?
So a joint obligation is where the whole obligation is to be paid or fulfilled proportionately by the different debtors and demanded proportionately by the different creditors. This is the presumption in all collective obligation unless solidarity is expressly stated.
So it means that an obligation of one person against another shall only be performed by the former.
Yes.
Even though there are other persons who have contracted with the obligee, same as the obliger's terms and conditions, it will still be performed individually. And the nature of the obligation in this case is separate and distinct from that of the other person. So actually, this is the general rule kasi yung solidarity is the exception.
Yes, it's the presumption always is joint kasi mas less burden.
Tingnan natin sa example, bakit nasabi ni Attorney Uy na less burdensome ang joint obligation. For example, there are three friends, si A, si B, and si C. So, sama-sama, nanghiram sila ng 15,000 pesos from X, the obligee.
The creditor. So, creditor ay debtors A, B, and C borrowed 15,000 each. Magkano
Each
yun?
pala, each.
15 times 3,
45,000.
Okay. X, si creditor. So, a month after, X demanded payment from debtors A, B, and C. C paid 15,000 as his payment for the said indebtedness. Now, X, the creditor, asked C for the remaining 30,000 pesos for the indebtedness of the other two. Can the creditor X ask for the performance of the whole obligation? Attorney Maralit.
The answer here is no.
No.
The creditor cannot ask C to settle the remaining 30,000 pesos because again, the obligation here is a joint one and performance shall be separate and distinct from that of the other obligor.
Yan.
Take note na si A, si B at si C ay
They're
nangutang
separate and
each.
distinct debtors.
Yes. So lahat sila ay tigpi 15,000 pesos.
And the creditor cannot demand payment from either one of them.
For
Yung
the
full,
whole,
for the whole amount.
Full amount of 45,000.
So, ang makokolekta lang ni creditor X kay C is up to 15,000. Kay A, 15,000. Kay B, 15,000. Hindi pwedeng kay C ay 45. O, hindi din pwedeng 30. Hindi rin pwedeng 20. Basta hanggang 15.
Yes.
O,
So,
yun
the
lang
creditor
share
here
nila.
cannot put the burden on the creditor,
Yes.
on C to collect the payment.
Proportionate lang. Separate and distinct.
And dyan papasok yung yung kaibahan ng joint sa solidary obligation.
Solid.
Solid. Because solidary obligation, in that case, there are two or more debtors who owe the same thing to the same creditor. That means there are two or more creditors entitled to the same obligation or two or more debtors under the same liability. Medyo nakakalito to, no? Pero take note that the obligation is solidary when the whole obligation can be performed by either of the obligors. If the whole obligation consists of several obligors, the performance may be performed by either of the parties. Okay, so let's give an example as regards solidary obligation. Yung kanina, si friends A, B, and C, they borrowed 15,000 pesos each from X, the creditor. And in their undertaking, A, B, and C bound themselves to pay jointly and severally the creditor X the full amount of 45,000 pesos kasi 15,000 times 3 yun is
Oo.
45,000 pesos. So, a month after, si X na demanded payment from C.
From
And
C.
C only paid 15,000 pesos as
Yan,
claiming that
oo.
it's his payment for his
His share.
proportionate
Oo.
share. Then, however, si X, inas pa rin niya si C to pay for the remaining 30,000 pesos pertaining to the indebtedness na kulang pa, no? Kasi 45,000 yun eh. Now, the question, Attorney Uy, is can the obligee, creditor X, ask for the performance of the whole obligation from C in this
Yes, dito pwede na.
Mhm.
Kasi the debtors bound themselves solidarily or
Mhm.
jointly and severally
Mhm.
for the performance of the entire obligation.
Mhm.
Tapos, the obligation may be extinguished by either of the obligors, and whoever pays for the said indebtedness may be reimbursed depending on their agreement. So, ang sagot, pwedeng magkolekta ang creditor ng whole payment kay C. To either one of them, pwedeng kay C, pwedeng kay A, pwedeng kay B, kukolektahin yung buong 45,000 pesos. Kahit 15,000 lang ang bahagi doon ni C.
Mhm.
Kasi nga, solidary.
May undertaking kasi sila na jointly and severally babayaran lang. And take note guys, na pag may nakita kayong words of solidarity dyan, halimbawa sinabing solidarily
Or jointly and severally.
Ibig sabihin nun, they undertake to
Be bound.
solidarily and to pay the full amount. So any one of them can pay that, of course, with the right to reimbursement.
Yes, naman. So, magbabayad si C, sabi ni X, o C, bayadan mo to lahat. Pwede, babayadan niya ni C. Kasi nga, the obligation is solidary. But C may ask for reimbursement to A and B.
Hindi naman pwedeng tatanggo yung dalawa kasi unjust enrichment and take note. So take note na
so babayaran ni A 15,000 from A and 15,000 from B.
Nababayaran nila
kay C.
And take note that on the last paragraph of Article 1207, as you can see in the Civil Code, the nature of the obligation, as again, a general rule, will always be joint, and it will only be considered as solidary if it is expressly so stated. So, if you're given a problem, you always look at the word of solidarity.
Kapag walang ganon, di joint lamang yan.
Okay, so we're done discussing Article 1207 as regards joint and solidary obligations. And going to Article 1208, please refer to your Civil Code, Article 1208. In these provisions, the solidarity cannot be presumed. And the purpose of the law is, of course, to show that debtors always have separate obligations. So, kasi papasok dito yung indivisibility kasi, di ba? So, ngayon, Attorney Uy, mahalagang mai-explain natin sa mga bata or sa mga viewers natin, ano ba yung difference ng indivisibility at solidarity?
So, indivisibility refers to the prestation, while solidarity refers to the juridical or legal tie that binds the parties.
So, secondly, as the indivisibility, only the debtor guilty of breach of obligation is liable for damages. Kung sino lang ang hindi makagampan, di siya lang yung liable for damages. While as regards solidarity, all of the debtors are liable for the breach of the obligation committed by one of them.
Kahit isa lang sa kanila.
Lahat sila liable.
Kasi nga solidary. So, indivisibility can exist although there is one debtor and one creditor. However, kapag solidary naman, there must be at least two debtors or two creditors.
Okay, so as regards indivisibility, in indivisible obligations, the others are not liable in case of insolvency of one of the debtors. In solidary obligations, the other debtors are proportionately liable when one of the debtors became insolvent. Yes. Kaya nakikita nyo, mas burdensome talaga kapag ang nature ng obligation mo is solidary. Right. Tingnan natin, examples, halimbawa si X and Y, they are jointly liable to deliver to, let's say, W a yacht. No? Yate. Social, yayamanin. Here, the object is indivisible.
Yes, yung yacht, delivery of the yacht.
Indivisible.
Indivisible
Pwedeng hati-hatiin mo yung yacht. Diba? But the obligation of the X and Y is joint. Bakit nasabing joint, Attorney Uy?
Joint because they are jointly liable.
Sinabi naman, jointly liable. So, joint lang yung kanilang obligation. Indivisible and yet joint obligation.
liability.
So, it can be considered as a joint indivisible obligation.
So, if X and Y require themselves solidarily to give the yacht to W, here, there is a solidary indivisible obligation. The delivery of the yacht to W is indivisible and the liability of X and Y is solidary because either of the latter may deliver.
So, malinaw naman na indivisible yung prestation natin, which is the delivery of the yacht. It's just that meron
The
silang
liability.
undertaking na ang liability nila ay solidary. So, pwedeng si X or pwedeng si Y ang mag-deliver nung indivisible obligation. So, again, that is a solidary indivisible obligation. Solidary obligation does not automatically make the obligation indivisible. Take note of that, kasi
So,
na-differentiate naman
solidarity
natin.
does not necessarily mean indivisibility.
So, halimbawa, si X and si Y, they solidarily promised W to pay the indebtedness in the amount of 100,000 pesos. Kung kanina, ang kanilang i-deliver ay yate or yacht, ngayon naman, ang i-deliver nila is 100,000 pesos as payment for their indebtedness. In this case, considered as divisible ang 100,000 pesos. Tama?
Susceptible of partial performance.
But, in this case, in solidary, yung kanilang undertaking, then the obligation is a solidary divisible obligation. Pwede ba magkaroon ng joint divisible obligation?
Yes. So, to have a joint divisible obligation, X and Y are jointly liable to pay the indebtedness of 100,000 to W.
So, in that
Divisible
case,
yung 100, yung payment ng 100K, and X and Y are jointly liable.
so they
So,
are
joint
supposed to pay
divisible.
50,000 pesos each
Yes.
kasi joint divisible. Yung kanina, solidary divisible obligation, either X or Y shall pay 100,000 pesos kasi solidary nga yung obligation na meron
Yes.
sila. So that's Article 1208 of the New Civil Code. And kanina may na-mention kami na joint indivisible obligation. If you'll notice, that's under 1209 of the New Civil Code. So please refer to your New Civil Code so that you can see it for yourself how joint indivisible obligation is defined by the codal provision. Also, na-mention din namin kanina na dinistinguish namin yung solidarity at
Versus
saka yung indivisibility. You can find that under Article 1210 of the New Civil Code. And also, pagdating sa Article 1211, nabanggit doon that solidarity may exist, although the creditors and the debtors may not be bound in the same manner and by the same period and conditions. So, depending on the agreement nga yan ng parties dun sa terms and conditions laid down or stipulated. So, ngayon, Attorney Oy, a more important provision that we have is Article 1212. Ano ba yung sinasabi ng Article 1212?
So, each one of the solidary creditors may do whatever may be useful to the others, but not anything which may be prejudicial to the latter. So, these are acts of solidarity creditor useful or prejudicial to the others.
So, ang sinasabi lang dyan, pag ikaw ay solidary creditor ka,
creditor,
yes, creditor, you may do any act provided na yung act na yun ay beneficial or useful, makakatulong sa other solidary creditors na meron. And it should not be prejudicial. Pag sinabing prejudicial, yung ikasasama or kumbaga ikapapahamak ng iyong mga co-creditors.
So, the reason or the rule is based on the theory of mutual agency among the solidary creditors. So, let's give an example.
Yes, of course. So, halimbawa, si A, he owes B and C solidary creditors to some, let's say, 10,000 pesos. And B, in this case, one of the solidary creditors may make a demand from the creditor, the debtor A, for the payment of the 10,000 pesos. And such demand, question, is that beneficial to the other solidary creditor, let's say C?
Yes.
Of course, kasi kapag nakakolekta siya,
mababayaran
mababayaran yung utang sa kanilang dalawa.
But in case of remission or condonation effected by B, the obligation will be extinguished, but since C cannot be prejudiced by the remission, B has to reimburse C for the latter's share. Kasi ano ba yung act ni B? Is remission or condonation prejudicial to C, the solidary creditor?
Yes, in that case, it is somehow prejudicial kasi kapag nagkaroon ng condonation or remission, kumbaga, tinatawag natin quits na donation na yun. So, hindi na bound to pay si A. Pero, in that case, without the consent of C, that is not useful or beneficial to the solidary creditor.
So, in that case, dahil nga solidary ang liability, wala nang obligation to pay. Pero si B, yung nag-remit or nag-condone ng debt, ay liable to reimburse C.
The amount of 5,000 pesos. Kasi 10,000 yung total.
Yes.
Okay? So, take note of that. Now, Article 12.13, a solidary creditor cannot assign his rights without the consent of the others. Kasi take note, diba, sabi natin, pwede na, may mga rights kasi na pwedeng transmissible or pwedeng i-assign. Pero general rule daw dito, pag solidary, hindi pwedeng i-assign without the consent of the others. Okay.
Of the other creditor.
So, kung mag-consent naman, wala problema. Pero kung hindi mag-consent, wala kang magagawa.
Yes.
Okay?
So, Article 12.14, the debtor may pay any one of the solidary creditors. But if any demand, judicial or extrajudicial, has been made by one of them, payment should be made to him. So, Article 12.14 talks about payment to any of the solidary creditor.
So, ang rule lang naman dyan, kapag ikaw ay debtor, pwede ka magbayad to any of the solidary creditors. Pero kung may nag-demand, no, judicially, sa court, or extrajudicially, nag-send sa'yo ng demand letter, yun ang preferred mo na bayaran.
Yes.
Okay?
Yun ang demand.
Yun ang demand.
Kung sino creditor. So, let's just give an example. A is liable to pay B and C, solidary creditors, 10,000 pesos. In this case, A, the debtor, may pay either B or C, yung solidary creditors, but if a demand is made by B, payment should be made to B. Yan yung sinasabi sa 12.14.
What if si A, despite the demand, nagbayad siya kay C instead of B?
Si B nag-demand, pero ang ginawa ni A kay C nagbayad instead of B. B is entitled to his share from A in case C does not turn over to B the latter's share. Ang sinasabi dyan, kung hindi tinurn over ni C yung share ni B na 5,000 upon payment of A, magiging liable pa rin si A to pay 5,000 to B.
Kasi nga may demand
Hindi ka doon nagbayad. Tinakbo nung solidary creditor. Magiging liable pa rin.
Normally kasi, ang request dyan ng isang creditor is to ask for reimbursement from the one who collected it.
Yeah,
pero
yung full amount.
Yes, pero since in this case, meron demand yung si B as a creditor kay debtor A, and despite that, kay C pa rin niya binayad, then he is taking the rest actually. Kapag hindi nagbayad si C,
hindi ni-reimburse
yung share ni B,
ikaw ulit ang magbabayad.
Okay.
If B and C demanded payment at the same time, A may pay either of them.
Same time.
If there are two or more debtors, only the debtor upon whom demand had been made is bound to make payment to the creditor who made the demand. For example, si A at saka si D, dalawa na silang solidary debtors. So, kung kahit kanino man kay A and D, mag-demand si B and C, maalin sa kanila ang magbabayad kay A and D.
So, kung sino lang daw yung nag-demand, doon daw sila magbayad.
Kung kanino humingi ng demand at kung sino yung nag-demand, doon magbabayad.
Okay.
At yun ang magbabayad.
Alright. So, let's proceed with another article.
Yes,
This one is
Article
Article 12.15, which if we're going to look at it, it talks about novation, compensation, confusion, or remission of the debt. We invite you to go to your civil code and look at the codal provision itself. So makikita natin dyan na ang pinag-usapan dito is liability of solidary creditor in case of novation, compensation, confusion, or remission. Take note that these are modes of extinguishment, and we will discuss this under Module 5 bago tayo pumunta sa contracts. Pero as early as now, may sinasabi na dyan na effects nitong mga to as regards solidary creditor.
Creditors.
Okay, ano ba ang effect ng mga ito? Attorney Uy.
So, the creditor who executed any of these acts should be liable to the others for their corresponding shares, considering that such acts are prejudicial to them.
Papasok
Nara
ulit
natin
ang
Article
prejudicial
12.12. The different causes of extinguishment of an obligation are discussed under Chapter 4, Module 5.
So, for example, si A, debtor, and B, CD, solidary creditors, in the amount of 30,000 pesos. So,
Yes.
meron tayong solidary creditors, meron tayong one debtor, si A, ang magkano? 30,000 pesos. If B, one of the solidary creditors, validly condones the debt in the amount of, let's say, 18,000 pesos, then in that case, ano ang magiging liability ni B? Himayin natin 30,000 ang utang ni A. Si B, kinondone niya ang 18,000 pesos.
Supposing na ang pautang ni B, C, D ay tig 10,000.
Oo.
Pero solidary ang liability.
Oo.
Although tig 10,000 ang share ni B, C, and D. So, pinautang kay A.
So,
Oo.
B, C, and D are supposed to receive 10,000 pesos each as solidary creditor, di ba?
Yes.
Kinondone mo yung 18,000 pesos, so ang
For
outstanding
example,
na lang is
si B
12,000.
nangolekta ng buong 30,000 pesos kay A. Si B na. Pero sabi ni B, condone ko na yung 18,000, 12,000 na lang. So in turn, ang paghahatian ni B, C, and D is only 12,000.
Oo.
So magkano yun? Tig
4,000
4,000 na lang sila.
dapat tingnan magkano? 10,000,
Dapat
di ba?
10,000. So kulang lang 6,000 yung kay C, kulang din ng 6,000 yung kay D.
Question.
Oo.
Yung bang ginawang yun ni B ay beneficial or useful kay C and D? Obviously.
Obviously hindi. Kasi
Hindi.
nabawasan yung share nila.
Therefore, may liability si B to make reimbursements. Magkano? Ang pinag-usapan natin
To make
dyan?
reimbursement for 6,000 each. Share.
So, magbabayad si
Si
B,
B,
na nag-condone ng debt na
Kay-
18,000 pesos kay C and D.
Kay C and D ng tig 6,000 pesos each.
Ayan, take note of that. But what if si B nag-collect siya ng 15,000 from A? Ano naman gagawin ni B doon sa 15,000 na na-collect niya?
So, hahatiin uli yun. 5,000, 5,000, 5,000. Since si C at saka si D is kulang pa ng tig 5,000, so B must account for that 5,000 pesos.
Take note of that. Okay, so we're done with Article 12.15. Let's proceed with Article 12.16. Attorney Uy, ano ba sinasabi ng Article 12.16?
So, 12.16 states that the creditor may proceed against any one of the solidary debtors or some or all of them simultaneously. The demand made against one of them shall not be an obstacle to those which may subsequently be directed against the others, so long as the debt has not been fully collected.
So that provision pertains to the right of the creditor to proceed against any solidary debtor. But we have to take note, guys, that this provision is not applicable to a joint obligation, but
Yes.
only as regards solidary
Solidary
obligation.
obligation.
It reiterates the rule that in a solidary obligation, for example, in this case, passive solidarity, anyone or some or all of the solidary debtors simultaneously may be made to pay the debt so long as it has not been fully collected. And in this case, the choice is left
To the solidary creditor to determine against whom he will enforce the
pwede siyang
collection.
mamili kung kanino
Yes.
niya sisingilin. Bigyan natin ng example yan.
So, A, B, and C solidarily owe D the amount of 3,000 pesos. D can collect from A or B or C alone or from any of the two of them or all of them simultaneously. Tapos, if demand is made on A, the latter cannot require D to make a demand also on B and C or to include them as party defendants, as D has the right to proceed against any one of them. If A pays D 1,000, the latter can still go against all of them for the balance as long as the debt has not been entirely satisfied.
So, yun nga, sinasabi natin sa Article 12.15, the applicability of the same as regards solidary debtors and
So,
any one of
the
the
rights
solidary
the right
debtors.
of the creditor to proceed against any solidary debtor. So the creditor has the right to choose whom among the solidary debtors
will be made to
to
pay.
pay
No?
the entire indebtedness.
Yes. May nabanggit ka dyan na hindi pwedeng i-compel ni solidary debtor na isama rin yung iba pang solidary
Yes.
debtors as party defendants. Ibig sabihin, kung magkakaroon ng kasuhan sa court, may choice talaga si solidary creditor dyan or si creditor kung sino among you as solidary debtors sa magiging party defendant niya sa court. Of course, ikaw naman as a solidary debtor, you have the right of reimbursement naman. You will proceed against the other solidary debtors for their proportionate share as regards the indebtedness.
Okay.
Now, let's proceed with Article 1217. The provision is quite lengthy and we encourage you to read the provision itself. And makikita nyo dyan na yung provision na yan, it pertains to the effects of payment by a solidary debtor.
Ito may payment na by a solidary debtor.
Bayad si solidary debtor
effect.
payment.
So, first, between the solidary debtors and creditors. So, payment made by one of the solidary debtor extinguishes the obligation. And however, the creditor for his protection is given the right to choose which offer is to accept if two or more solidary debtors offer to pay.
So there is payment here, and take note guys that the legal definition of payment here is full payment. Hindi mo pwedeng tawagin payment yan kung yan ay partial payment lang.
Correct.
So there is a presupposition that the payment is in full and therefore supposedly, well, extinguish yung obligation ng solidary debtors na meron tayo. And ang mangyayari doon,
if two or more solidary debtors offer to pay the entire obligation, then the creditor may elect or may choose which among them
to collect from. Now, as between the solidary debtors, ano naman yung effect?
So, ang effect kanina, between solidary debtors and the creditor, it will extinguish. Pero may extinguish din ba when it comes to the solidary debtors? The answer is no. Because among the solidary debtors, the paying solidary debtor can demand reimbursement from his co-debtors for their proportionate shares with interest only from the time of payment. Ayan, may interest pa. So, meron din namang nakukuha pala yung paying solidary debtor.
Ay kasi kapag nag-delay naman sa payment itong si
yung
other solidary debtors, in a way parang nangyayari dito guys, si solidary debtor na nagbayad naging creditor
nung kanyang solidary debtors.
So the other solidary debtors are supposed to pay their contribution on time din naman. At kapag hindi sila nagbayad on time, may interest din naman na pwedeng i-collect sa solidary debtor who paid the same.
Reimbursement ang remedy niya. So, pantatlo, yung effect among the solidary creditor. So, the receiving creditor is jointly liable to the others for their corresponding share. So, doon naman sa receiving solidary creditor, ikaw naman, you have the responsibility to deliver the proportionate share of each one of the solidary creditors.
So, for example, si A, B, and C are jointly and severally liable.
Ibig sabihin ng jointly and severally solidary.
So, A, B, and C are jointly and severally liable to D and E in the amount of 3,000 pesos due on January 5. So, if both A and B, for example, offer to pay D on January 5, then D may choose as between A and B kung kaninong offer ang kanyang tatanggapin.
Correct.
If si A, nagbayad siya ng entire amount of 3,000 pesos on January 5, then we know that that's between the solidary debtor and the creditor. The obligation is extinguished. Now, the payment by A gives him the right to demand reimbursement from
B and C
Magkano?
of 1,000 pesos each.
With
interest from January 5, yung date of payment.
But, you know, A is not entitled to reimbursement nor to interest for any payment made before January 5. Kasi huwag kang bida-bida.
Hindi pa naman
Hindi pa naman due date,
pinagbayad
ka agad. Okay. So, the obligation of B and C to reimburse him with interest will only arise from January 5, the period provided as the due date.
The date.
What if si C one of the solidary debtors ay naging insolvent, no?
So dito, both A and B shall bear his insolvency in proportion to their shares. Hence, A can still ask B to pay an additional 500 pesos. If A and B can later on recover from C should the latter's finances improve. So, ibig sabihin, if one of the solidary debtor is insolvent, so the other solidary debtors may be asked to bear the
Shoulder niyo.
they will be asked to shoulder the share.
So in this case kasi,
their proportionate share.
ang total na utang ni solidary debtors A, B, and C ay 3,000 pesos. Si A nagbayad siya, kaya na-extinguish yung obligation eh. Then A is supposed to receive tig 1,000 pesos from B and C. But B became insolvent. So ang sinasabi dyan, proportionate share, ibig sabihin yung 1,000 pesos na loss because of insolvency, paghatian ni A at saka ni C. Kaya tig 500 sila dun sa
so tig 1,500.
Tig 1,500
so,
sila.
ang sabi naman dyan, kung mag-improve ang finances ni B, pwede naman mangolekta si A ng 500 at si C ng 500.
So, babantayan nyo na mag-insolvent ang si B.
Yes, kayo naman ay magkakilala, kaya kayo ay solidary.
True. Hindi naman kayo normally magsa-solidary kung hindi kayo
magkakilala. Oo.
Halimbawa naman, sa example natin, si D as one of the solidary creditors. Solidary ba or creditor lang?
Solidary.
As one of the solidary creditors, he has the obligation to give to E his corresponding share in the credit. Kasi sa kanya ibinayad ni A, di ba? Yung amount na 3,000 pesos. So, there is mutual agency, yung binabanggit nga ni Attorney Uy. And the fact that he was able to recover the amount of 3,000 pesos, then he has the duty and responsibility to remit the amount of 1,500 pesos to E, the proportionate share of his co-solidary creditor. Okay. Take note of that. Okay. Now, Article 12.18.
So, payment by a solidary debtor shall not entitle him to reimbursement from his co-debtors if such payment is made after the obligation has prescribed or become illegal. Article 12.18 speaks of the effects of payment after obligation has prescribed or has become illegal. So, it presupposes that the obligation has already prescribed and illegal na yung obligation. But, one of the solidary debtor is still fulfill the obligation or still paid the amount of indebtedness. So, ang sabi dyan, he has no right to reimburse.
He's doing that at his own risk. Kasi take note guys na, di ba, as a general rule, when one of the solidary debtors pays the obligation is extinguished and the solidary debtor who paid is entitled to reimbursement from his solidary debtors. As a general rule. But there are two exceptions na sinasabi dito. Nagbayad ka, prescribed na yung action. Pangalawa, nagbayad ka, illegal na nga yung it has become illegal. Then in that case, you're taking that at your own risk. Take note guys na ang prescription under Article 1231 paragraph 2. By prescription, in this case, we mean that one acquires ownership and other rights through the lapse of time in the manner and under the conditions laid down by law. So in the same way, rights and actions are lost by prescription. So pwede kasi may karapatan to collect, for example, ang creditor, pero there is a time limit for them to exercise
provided
their
by
right.
law. For example,
provided yan ng batas.
Is when it is based upon a written contract, dapat 10 years
within
from the
10
time
years.
the cause of action accrues.
So, halimbawa, nagkaroon kami ni Attorney Uy ng utangan na written contract of loan. Today is 2020. Then, I have 10 years
to collect,
within which to collect from him the indebtedness. Kasi upon the lapse of 10
years, wala na, prescribed na. Hindi na ma-extinguish na. Prescription is also one of the modes of extinguishment, although it is not expressly mentioned do sa provision, pero it is another way.
Yes, and I have to emphasize din, yung sinasabi ko kaninang 10 years, it's a record from the time the right of action accrues. Not from the time na nag-execute kami ng contract, no? But at the time na it has become due and demandable and may right of action. Halimbawa ay in 2 years, kailangan bayaran
niya.
ni Attorney Uy,
Yes, but-
based on our written contract.
Halimbawa, 2020 nangutang, sabi babayaran 2022. Ngayon 2022 na hindi pa nagbabayad, so doon magsisimula yung 10-year period if based upon a written contract.
So, take note guys na kapag halimbawa, 2032 na.
Oo.
Yan. O, lampas na.
2032,
Naka 10 years
Oo,
na.
o kaya 2033.
Oo,
Doon mo na,
2033.
singilin, wala na. You cannot anymore collect because the obligation
Has already
prescribed.
So, in that
Oo.
case, for example, 20,
Extinguished na.
2033 na nga, nangolekta itong si creditor from one of the solidary debtors in good faith. Kahit in good faith actually,
Oo.
nagbayad siya. Tapos ngayon, punta siya dun sa solidary
Solidary
debtors,
debtors.
diba? Asking for
Oo.
reimbursement. Anong sagot? Can he be entitled?
cannot reimburse under Article 1218. Oo. Kaya dapat alam nyo yan, hindi kayo basta bayad din ng bayad.
Alamin niya yung prescription,
Oo.
ano? Under Article 1230.
Kahit in good faith nagbayad, sabi nga ni Attorney Maralit, sabi, in good faith naman ako, nakokonsensya kasi 11 years na or 15 years na nakakalipas, hindi ko nababayadan, so nagbayad. The solidary debtor cannot collect or cannot reimburse or cannot be reimbursed.
Yes, and this is based on law, guys, and everyone is presumed to know the law. So, kahit in good faith ka, you are supposed to know this provision of law.
Yes.
Okay? Now, and the same thing applies kapag naging illegal naman.
Illegal,
Okay?
okay.
So, kung subsequently na declare as illegal yung transactions or
yung transactions,
yung obligation originally, and yet nagbayad pa rin sa solidary debtor, hindi siya
cannot be reimbursed.
Cannot be reimbursed. Okay? So, Article 1219, Attorney Uy.
So, the remission made by the creditor of the share which affects one of the solidary debtors does not release the latter from his responsibility towards the co-debtors in case the debt had been totally paid by any one of them before the remission was effected. Oh,
So,
may
in this
remission
case,
dito.
May remission,
Mm-mm.
may remission in one of the solidary debtors. Eh, ang problema mo, bago
nag-payment na.
May bayad
May
na.
payment na. Tapos tsaka yung one of the solidary debtor has already paid the whole indebtedness. But after the payment, yung creditor ay sabi, wag mo nang bayadan.
In one of the
May
solidary
remission.
debtors.
In one of the solidary debtors, sabi, ikaw B, wag ka na magbayad sa akin. Ayan na, anong effect nun? So, Article 1219 is the answer.
In that case, the solidary debtor to whom his proportionate share in the obligation has been remitted is still liable to reimburse or pay the solidary debtor who has earlier paid in full the obligation.
So, ibig sabihin, yung remission affected by the creditor after one of the solidary debtor has already paid the entire obligation has no effect to the other solidary debtors. So, let's give an example.
Halimbawa, si A and B, they are liable in solidum. O pag nakita nyo yung term na in solidum, it pertains solidarity. And therefore, they are solidarily liable to the creditor C in the amount of 1,000 pesos.
1,000.
Si creditor, dahil siguro kaibigan niya tong si A, niremit niya yung share ni A doon sa...
For example, niremit yung 500 ni A, wag na.
So, sabi niya, A, wag ka na magbayad ng 500 pesos. Subsequent payment by B of 1,000 pesos to C will not entitle him to reimbursement from A. Since, again, the remission extinguished the obligation with respect to A's share. Ito kasi yun, subsequent to nauna muna yung remission dito bago nag-full payment itong si other solidary debtor. However, B, the other solidary debtor, can demand the return of 500 pesos from C under the principle of solutio indebiti naman. So, not because of the solidarity of their obligation, but because of the principle of solutio indebiti in that case. Okay? But if payment by B was made before the remission, titignan nyo kasi kung kailan ba ginawa yung remission, before or after the payment of one of the solidary debtors. So if in this case, after the payment na ni B yung remission na nangyari, then A is still liable to B because the remission is without effect, the obligation having been extinguished by
the payment.
So, take note of that,
Take
guys.
note of Article 1219. So, let's now proceed to Article 1220.
Ano ba
The
yan?
remission of the whole obligation obtained by one of the solidary debtors does not entitle him to reimbursement from his co-debtors. O, dito, yung
Yung
sinasabi lang
1219 kasi, remission ng share lang, hindi
Oo,
full.
oo,
Dito,
oo.
buo na.
Oo, buo. Dito, ang ginawa, may solidary debtors. Tapos may isang, for example, may isang creditor. Sabi ni creditor, ang utang nyo sa akin na 30,000, lahat-lahat, pati yung share ni B, share ni C, wag nyo nang bayadan, okay na.
Total
Dahil
friends naman
tayo.
tayo. Yeah.
Libre ko na din yung friends mo, B and C. Ang tanong, is A entitled to be reimbursed by B and C?
Pwede ko ba sabihin na ako naman talaga yung friend nun eh. So, kung hindi naman dahil
Dahil sa akin, hindi
ko
naman kayo
i-remit.
maano, so bayadan nyo ako.
Can that be possible?
Hindi, under Article 1220. Hindi naman. Sobra ka naman. Nilibre ka na nga din. Gusto mo pang kunan yung other solidary debtor. Unjust enrichment ang tawag doon.
Yes.
Okay? Okay na tayo. 1220.